Hello my friends. Today we discuss how do we get an extension of time period to complete the arbitration process if the initial time period prescribed under the statute, that is the Arbitration and Conciliation Act, has expired. To recapitulate, the Arbitration and Conciliation Act provides that you would have 1 year from the date we complete pleadings, that is the claim statement, then the written defense, and if the rejoinder is allowed, written rejoinder. Once this process is completed, from that period, a 1 year period is calculated and you have to complete the arbitration within that time. Now, supposing we do not finish the arbitration, then the parties are at liberty. Both the parties have to agree for an extension which can be mandated till around 6 months. What happens after that period of extended 6 months, or if one of the parties doesn't agree after the initial 12 months? Then the remedy is to approach the court for an extension of time period to complete the arbitration under section 29A. Now the important question which arises is, which court do we go to for this extension? Interestingly, the word used under section 29A of the Arbitration and Conciliation Act is court, is just court. Now court under 21E, when it defined in the domestic arbitration regime, is the principal court of civil jurisdiction. Remember this, principal court of civil jurisdiction, where the subject matter is situated or cause of action has arisen. There is another section, which is section 42, which says if there is a particular application which has been filed in a particular court of principal court of civil jurisdiction, supposing there are 2-3 courts where one could go to, then you have to go back to that one court where the original application has been filed. So these are different competing things which you have to keep in mind when filing that application for 29A. Initial years, immediately after the amendment, a lot of applications were being filed in the district courts where the subject matter had arisen, where it would have been 21E, and you would have to go to that particular district court for getting any kind of remedy under the Arbitration Act. It is that same court where you could have filed a section 9 interim application. Now, there is another provision, that is 29A subclause 6, which allows that court which you apply to remove and alter the arbitrator. Now, to remove and alter the arbitrator and appoint somebody another person in its stead, would be akin to section 11 of the Arbitration and Conciliation Act, which allows for appointment of the arbitrator. Now comes quite a paradox, because section 11 is the exclusive privilege of the High Court in case of domestic arbitration, and it is the exclusive right of appointment conferred to the Supreme Court with relation to international commercial arbitrations. So, in domestic arbitrations, it would then seem that a district court, which would otherwise be the principal court under 21E of the Arbitration and Conciliation Act, could remove an arbitrator who has been appointed by the High Court under section 11 and appoint somebody else instead. Now, this dichotomy was brought to the notice of various high courts across the country. And thankfully, the legislative mistake, and I must indicate this must be a legislative mistake. You cannot use the word court, which is defined separately in a different way, was interpreted by the different high courts to give a harmonious construction. And the Bombay High Court in a judgment in Kabra, Gujarat High Court in Nilesh Ramanbhai Patel, Delhi High Court in Tara Chand, and as well as the Calcutta High Court in Amit Kumar Gupta have now interpreted that word court to mean that high court where you could have gone with one of the parties could have gone, that is, to get an appointment of an arbitrator. So now we have to remember this, that when we are going to file an application for extension of time for the arbitration to continue, 29A is the provision, and you have to apply only to the High Court. Please do not apply to any other forum which will not be entertained. One more important consideration which should be kept in mind is that today another amendment was taken in 29A, so which allows for arbitrations to continue if an application has already been filed. Primary consideration was because 29A applications for extension of time were being held up in high courts, and the arbitration process, which was otherwise supposed to run quickly, were getting stalled. It has its problems, this kind of an amendment, which I have discussed in another video, which you can see. But otherwise, this was the basic criterion, and keep these things in mind. If any of the people are more interested to have or they need the judgments, please let me know in your comments, and I will share the judgments or any other issues which you might have. I may elucidate on the same. Thank you. Have a great day and a great time filing Section 29A applications. Bye. Thank you.